Welcome back to Law News Network. I'm Allura Nanos. We're on a lunch break for the Adrian Loya trial, and I am joined today by my fellow Law News host, Aaron Keller. Aaron, how you doing?
Pretty good.
So we're talking about mental state in this case, because up until now, everything has just been prep. Up until Dr. Kelly, I don't want to say it doesn't matter, but none of this is about the ultimate issue of the case. What Dr. Kelly is saying, he's the first witness where what he says goes to the heart of what this defense is, which is this guy has a mental problem, and because of that mental problem, he should be found not guilty.
Well, it's interesting that it goes to the heart of what the defense is, because it's a prosecution witness.
Yes, that's a little weird.
So a couple of interesting procedural things happen here. First of all, I kind of sort of agree about what came before this, because I said yesterday, for the record, that we know it was a horrific crime. The defendant admitted not just once, not just twice, but 20 million times that he's the one who did it, that he planned it, okay? That's all pretty clear cut. The jury needed to hear it all, though, because the state has to prove its case beyond a reasonable doubt. So all this other testimony has, in the judge's own words yesterday, clearly shaken several members of the jury. Okay, he was afraid to let them see some of the videos because he thought it would inflame them even more. So that all said, this is going to hinge on whether or not the jury believes that this defendant was suffering from a mental disease or defect, and I think the key word is defect more so than disease, okay? So they have to determine whether or not a mental defect rendered him to the point that he basically couldn't understand right from wrong. And apparently this witness who was on the stand through most of the early part of today was hired by the prosecution or retained somehow by the prosecution, and then ultimately came down with a conclusion that the prosecution didn't like. And rather than just be accused of doctor shopping, looking for another doctor who would just agree with the prosecution, apparently the prosecution is going to put on several experts and say, okay, let's discount this guy for these reasons because the other so-called better experts would say that he at least knew right from wrong.
I think that's going to be a really tough job for the prosecution to do that, because the witness is highly credible. The witness is a fantastic witness. So for the prosecution to put this guy on the stand, knowing he's going to be on the stand for 10 hours of testimony, and then come back and say, well, ignore everything he said, I think that's ridiculous. I think it's really difficult for them to do that.
Well, I didn't say it was easy. I'm just saying that that's what they're going to do.
Right.
I mean, look, Massachusetts is one of the states that allows the person who calls a witness to impeach the witness. So the state needs to impeach him after calling him, and I'm not sure that they've succeeded at that yet. I haven't heard all of the testimony, but that's what I'm really curious about. So, and how are they going to do that? Your opinion seems to be that they're not doing a very good job of it at all.
I don't know that the prosecution has really tried to do that yet. I don't know that the prosecution. That's
scary. Then.
Yeah, I mean, from what I saw, they put the guy on the stand and they said, "What'd you think?" And I don't know that the prosecution has even asked any questions that go to the heart of his credibility. Certainly, he's qualified as an expert. It's not like he has any kind of weird credentials or there's any reason to not believe him from the get-go. And then if you look at the substance of his testimony, and if you look at sort of the style of his testimony, I think it's coming across in a highly credible manner. Now, that doesn't mean that I think every single thing he said is perfect and could never be contradicted. But I think if you take it in totality, it would be difficult to say that this guy isn't doing a good job. He's doing a really good job.
So how does the prosecution sustain its burden of proving that this particular defendant is not suffering from a mental disease or defect? Because ultimately in Massachusetts, once the defendant raises that defense, the way it works in Massachusetts is the state then has to leapfrog over that defense or clear that hurdle in order to sustain its case. So state makes its case, defendant raises the defense, the state then has to leap over it if the state wants a conviction. How does the state do it?
I mean, they're going to have to do something better than I think what's happening right now, because what we have here is a doctor describing Asperger's syndrome for exactly what it is. Then we have the same doctor saying that this guy was like a textbook Asperger's syndrome case. And I think that that's really difficult to get around, because it's not as if the doctor is describing something that is highly unusual. It's not as if he is describing the symptoms of that disorder in a way that those symptoms constitute things that for example, the jurors have never heard of. This is not an obscure disorder. These are not obscure symptoms. And he's not even saying, that this individual, that Adrian Loya, had symptoms that were really extreme. He's basically saying, this guy had Asperger's, this is what many people with Asperger's have, this guy fits the mold exactly. And I think that when you have that kind of testimony, it's almost impossible to get around it, unless, of course, and here's what I would say.
Let me stop you for a minute, though, Laura, because here's the thing. So what if he has Asperger's? Does he know enough to conform his conduct with the law, or does he not know right from wrong? I mean, this is the legal standard that we've got to get into.
And I think that the doctor brought up kind of an important way, a filter to see this through, because he is not on the stand saying no one with Asperger's could follow the law. He's certainly not saying that. He's not saying if you have Asperger, you're going to be an automatic rule breaker. In fact, quite the contrary tends to be the case. But what he is saying is, look, there is a real significant chance that Adrian Loya saw the entire situation here as a major injustice that he needed to right, that he needed to put on the just track, and that the only way he could do that is by committing murder. And whether or not that's reasonable is sort of a different story, but that is the filter that he's asking us to see this through, that there is a larger, more global battle between right and wrong. And in this case, right and wrong did not correspond with legal and illegal.
Okay, well, if that is the case, and he thought that he was this agent of God or something, like bringing justice out to someone who had wronged him, how do you get over some of the other statements that he made which would indicate that there was a wrongfulness element that he at least recognized by his own words? He did it more than once.
Yeah, I agree. I mean, I don't think that it's ever going to be easy to take not guilty by reason of insanity as a plea and just feed a jury, hey, this is the problem this guy has, therefore why don't you acquit or find him not guilty by reason of insanity. I think that it is difficult, and there's going to be those pieces that are difficult to get past. But I think ultimately in this case, it's really going to come down to our best guess and the jury's best guess as to whether the symptoms that this person was experiencing are enough to have impacted his decision to commit this crime.
Okay, well, we've got a couple of what ifs then. Why is it that he thought the police were going to show up and shoot him if he was unable to recognize right from wrong?
But that is the difference. And there's been case law on this about understanding the difference between right and wrong is not necessarily the same thing as understanding that the police might think that you're doing wrong. So in that world, for example, if a person believes that they are doing the right thing from a moral standpoint, but that thing is considered illegal from a law enforcement standpoint, it is possible that the person could be found not guilty by reason of insanity because they are unable to really understand the difference between right and legal, because they're not necessarily the same thing. So it is possible under the law that Adrian Loya knew that the police would be after him, knew that law enforcement would be after him, knew that this conduct broke the law, but still honestly believed that he was doing the right thing from a moral standpoint. And I think that's going to be the toughest place that this could go.
Well, let's back up, because I've committed the sin of paraphrasing a statute by boiling it down to say, did he recognize the difference between right or wrong? And of course, lawyers know never to do that. The details are what's critical. Here's the model jury instruction in Massachusetts. A person is lacking in criminal responsibility if he has a mental disease or defect.
Which we know, we'll get rid of that phrase because we know that he has one, right?
And the result of that mental disease or defect is either that he is substantially unable to appreciate the criminality, the wrongfulness of his conduct. That's the first prong of it. So let's break it down.
Which I will submit that that's the one you're talking about.
Substantially and criminality. He would have to be unable to substantially appreciate the criminality of his conduct. Well, if he knew the police were going to show up,
then he knows it's criminal.
He knows it's criminal.
I agree.
Okay,
and that's
so that one falls.
Yep.
That one falls. Or,
but there's an or.
Or,
yep.
So he can try to slide under this one. He is substantially unable to conform his conduct to the requirements of the law.
And
Substantially, I think, is the key word there that's going to sink him.
Well, I think substantially is an important word in there, and I think unable is important because really what this requires is him saying, I couldn't not do this. I had no choice but to do it based on what my brain was telling me to do at that moment. And I think that is, I mean, it's not easy, but I think that his best shot is to.
I think
go
there's
the
a
way
second way to
defense is
read
going.
this. I think that the other way to read it is substantially unable to conform his conduct to the requirements of the law. What I read into that is something that has to do with almost like intelligence quotient or something like that. And I might be mincing it a little too far, but unable to conform conduct to the requirements of the law, to me, is a pretty high bar. In other words, if you can read the law and understand what it requires of you, you can't claim that.
Well, my understanding
understanding
is that the law behind unable to conform behavior comes out of what used to be called the irresistible impulse test in some states. That when someone, by virtue of a mental issue, cannot control themselves, that falls under that. And Massachusetts has taken the broadest possible version of the jury instructions for not guilty by reason of insanity, because it basically takes 3 different standards, smushes them together, and says, if you got any of these, you got a not guilty by reason of insanity. And I think that the defense here, that he was compelled to do this because of the way he understood the surrounding circumstances and the way he understood what was going on in his life, I think that that's a compelling argument. I think that it's going to depend on the jurors having a closer understanding of what was happening in his head. And I don't think a doctor saying, here's what Asperger's means, is enough. I think it's going to require some more than that. But I think that this doctor set us on a track to go there. And I think it definitely could go there. But again, we're going to end up always with this one problem, which is there are people with Asperger's whose behavior would be defensible under this statute. There are people with Asperger's whose behavior would not be defensible under this statute. Where does this guy's behavior fall? And ultimately,
well, of course, that's
we
the
don't
only
know.
question. You know,
Right?
we're
We
not
don't know.
judging everyone who has
That's right.
this diagnosis. We're talking about what this guy was up to.
And I think that this now, this diagnosis throws a whole curveball into it. That's difficult to process by just kind of saying, well, none of us know what was happening in his head at that exact moment. None of us can say, well, he definitely knew right from wrong, or he definitely did not know right from wrong. So I think it makes it a tough call, but I think that Dr. Kelly's testimony is critical. I think it's going to be really difficult to impeach him. I think this is a bell that's going to be really difficult to unring, and we'll just have to see, what happens next. For now, what I'd like to do, I'd like to go back and play a little bit more of Dr. Kelly's testimony from earlier today, and we'll see. We'll see what happens when the prosecution comes back on to impeach this guy.
You said the type of autism, police doctor, was the high-functioning Asperger's, and you gave us a few examples of that. And I'd just like to ask you about that. When you talk about high-functioning, and you mentioned a particular author, in fact, now a doctor, Temple Grandin, how does that play into Mr. Loyer's case?
Well, it's an example of someone who's very functional, but has Asperger's disorder, knows she has Asperger's disorder, is able to use some of the aspects of her disorder to see and understand things that the rest of us would struggle to understand until she kind of explains it to them. So one of her great contributions has to do with animal welfare and feedlots and cattle and stuff like that. And she's been on 60 Minutes and she's interviewed fairly regularly. And she's a spokesman for people with Asperger's disorder, trying to reduce any stigma that's associated with it, but also to generally increase understanding.
Now, again, you used, and I just want to focus for a moment on the term high functioning. That's functioning, meaning you or I may not even notice it in a particular individual because they're functioning in day-to-day life. Is that fair?
Yes, that they're able to have a job, take care of themselves. They're not institutionalized. They're not living with their parents and being taken care of. Some in the autism spectrum are, but some, a small number, a relatively small percentage, can function pretty well in the world if they find tasks that are simpatico with their disorder and can socialize, particularly in situations that are not particularly ambiguous.
Okay,
With-
well, let-
With
Oh,
all
I'm
due
sorry.
respect to the Coast Guard or any military organization, who's the leader is pretty clear, okay? You go up the rank and it's not ambiguous, okay? In a social situation, who's the leader of the group is not by how many stripes you have, if you will. And so military or very structured environments are easier for people with Asperger's to deal with and be in. And the same with
Disease, a disorder, the autism, he fit in relatively well in that secluded base
yes.
as a petty officer. Now, you mentioned Lisa, Doctor. How, if at all, did that affect Adrian Loya or their relationship?
That's a big question. I mean, that's a big topic. He arrived in July of 2011, and he was there for a few months. She arrived in the early fall, and he may have seen her at work, but that was not particularly memorable to him. They had one of these morale events in which they had a picnic, and they were by a river, and they were doing some fly fishing, and he eventually kind of went off a little bit by himself and separated himself from the group and was there kind of taking in the surroundings. And Lisa sought him out and came up to him. And that was the beginning of their relationship. And she was pleasant and funny and smart and outgoing, and he liked talking with her.
So, was her connection / friendship with him and at all, in your opinion, Doctor, in those early stages, abnormal?
Well, it was more platonic friendship. Eventually, over the late months of that year, 2011, he came to find out that she was in a relationship. He eventually found out that she was engaged to be married, and eventually that she was engaged to be married to another woman. And that kind of evolved October, November, December. In December, she left and was married at the end of December.
What, if anything, did that do to their relationship as it was at that time?
At that time, prior to her marriage, it was friendly, platonic, not particularly boy-girl kind of thing. Her car broke down, so she needed a ride from off base to work. So for several weeks, they would drive to and from work together, and that's how they got to know one another and their personal stories.
Do you have the inability at that time to register the cues that normally functioning human beings would?
Well, he didn't have a complete inability to do that. I'm trying to suggest that there is a spectrum. He did not, once he found out she was in a relationship, he didn't appear to be interested or follow through on that. And that's kind of the literal kind of way he does it. Don't have a relationship with someone you work with, okay? That's kind of one of the rules that he's kind of picked up along the way. So but he very much enjoyed being with her, enjoyed her friendship and the like. In the time frame now, late 2011.
When you just said you said one of the rules, is that a moralistic stance that he
Well,
holds?
it's a good idea not to have a relationship with people you work with, but for him, it's like people intuitively know that. Most people intuitively know that. For him, it's like, okay, I get it. It's kind of a rule, but it's almost like he has to be told it or has to have heard it, or it's not like the intuition that most people would have.
Or to fraternize with somebody who's a subordinate in the military service?
Correct.
Now, upon or after their marriage, did you get some information about Anna and Lisa going back to that Kodiak base?
Yes.
And how, if at all, did that affect Adrian Loya and Lisa's relationship?
Well, they arrived back on the base in January of 2012. And Anna and Lisa were now living off base, and they were newlyweds. And the first encounter, I believe, was kind of a social event in which people in the group, the shop, the little unit, decided that they would like to meet Lisa's spouse. And so they gathered, I think, at a bar. She was introduced and things of that sort. And that was pleasant enough. And then there was the first of what is a lot of incidents. He, for some reason, could not get packages delivered to where he lived. So Lisa said, you can have your packages delivered to my place and you can pick them up there. And that had been a pattern that had gone on well prior to the marriage in the fall. One day after work, he and a friend went over because there was a package for him at Lisa and Anna's apartment. He went to pick up the package, and Anna seemed annoyed or something of that sort. It was not kind of just giving him his package and saying, okay. And he thought that was kind of strange. And then Lisa brought it up to him afterwards, saying, don't go to the apartment without calling ahead. Now, he would characterize that as Lisa yelled at me, but I think it's unlikely she was yelling at him. She was just saying things, but he would process any negative thing as a, quote, yell or something stronger.
So let me ask you that. Is it his disease, doctor, you're saying, affects his ability to interpret
Correct.
another? And
Correct.
that's one of the...
But again, not total, but mostly, significantly, but not absolutely, like a very disturbed autistic individual, child or adult.
So again, not a total inability to recognize what happened.
Correct.
And you indicated, just if you could briefly, were there other incidents in and around that time? You talked about a mail drop. Was there an incident at work when he had to actually give her an order to go out and get another fellow named and come back in?
Yeah. There were many instances, and his memory is much better than mine is going to be, okay? The situation with Luke was, he was kind of, had a higher rank and would give assignments and, quote, orders, but he was not one of these give orders kind of guys. At any rate, Lisa and Luke liked to work together, and they would kind of set it up that they would, in his opinion, arrange to kind of scoop the project so the two of them could work together. At a particular point, he said there was a certain thing to be done, and he basically told her to do this project either with him or with someone else, but not with Luke. And she got upset, quote, yelled at him, but mostly when she would get upset with him, she would not speak to him at work.
How did Adrian react, first say, to the mail drop incident?
Picking up the package,
Yeah, that,
he was kind of confused. He didn't understand what the problem was. He was there with someone else just to pick up a package. What was the problem, if you will? But he had been told, don't go over there unless you call ahead of time. And he was just puzzled by it.
Welcome back to Law News Network. I'm Laura Nanos, still here with Aaron Keller. And so, Aaron, we can't agree on whether or not we think that Adrian Loya has a really solid defense by using
You're
Asperger's,
assuming
huh?
that I have personal opinions based on what I'm arguing with you about. That is wrong.
At a minimum,
I will just
we can
argue
have a
with
spirited
you.
debate. You'll just argue to argue.
I will just argue to argue.
So, but here's the thing, though. That's actually pretty important in this, because the bottom line is, under the law in Massachusetts, if it's unclear whether or not the defendant has a legitimate not guilty by reason of insanity plea, the law says the jury has to weigh on the side of using it as a defense. So
Yeah,
that's
I mean,
big.
it has to do with burden of proof. So at the end of the day, once the defendant raises the hurdle, if the state can't jump over it, then it's not guilty.
So basically what we have here, so there are three kind of choices, right? There's the defense raises it, the prosecution overcomes that hurdle and gets a conviction. Then there's the defense raises it, the prosecution cannot overcome it, and there's not guilty by reason of insanity, which is not an acquittal. But
Once the defendant raises this issue, the prosecution has to prove two things, and this is in the jury instruction as well. I know we were nitpicking a couple of parts of it, but it's a couple pages long. The prosecution needs to prove that he committed the crime. Well, he's pretty much given up on that fight. He did the act.
I mean, and that goes part and parcel with any not guilty by reason of insanity plea. It requires pretty much that the defendant say that he did it.
Yes.
Because otherwise the second part doesn't make any sense.
So the defendant committed the acts. The next question is whether or not he was sane. And if the jury isn't sure beyond a reasonable doubt that he was sane, this is not guilty.
Right. So, I mean, basically the choice is, we know the prosecution is right, we know the defense is right, or we're not sure. And if you end up in we're not sure territory, that's a defense win here. And the fact that we're having this debate over just this first doctor's testimony, to me, shows that's where we're headed. We're headed to the jury saying he could have been not guilty by reason of insanity. It is possible that his Asperger's syndrome prevented him from knowing the difference between right and wrong. He certainly had a mental defect. The question is, how far did that go with respect to him conforming his conduct or understanding what it meant? And if that's the case, if we're not sure, the law says that we have to say he's not guilty by reason of insanity.
I really want to hear what the other experts are going to say here,
Right.
because my whole thing is like, okay, well, you can conform your conduct to what the law requires if you're in the Coast Guard and you can follow their practices and procedures. It's sort of like, at the end of the day, you can choose a couple different tracks in life, and if you want to choose the violate the law when you can do it. And it seems to me that this guy doesn't have a mental defect that's sort of like ripping up the train tracks. It's like he can see a couple different paths.
Perhaps, or
he
perhaps.
walks into the. Well, if he couldn't follow orders, then he wouldn't have lasted in the Coast Guard.
Well, here's the thing, though. I will grant you that you're correct about that, but I will say this, though. A person who chooses a military lifestyle may be very well a person who needs clear orders, clear conduct that is specified and laid out for him ahead of time, so that he's not in an ambiguous situation very often. Many of us in our jobs are in morally or legally ambiguous situations every day and have to make difficult calls. If you're in the military, though, you're not in that ambiguous turf very often, because your job is to follow orders and have that be it. So if you're a person who has a difficult time navigating ambiguous situations, the military may be a very good fit, because you won't be asked to navigate those situations very often. Where it may be true that this situation with this victim is the first time, or maybe the most dramatic time, of course, that Adrian Loya was ever in a situation where what the law required differed so greatly from what he wanted to do or what he felt was correct. I mean, that's the counter argument, is that the military was the perfect place for him because he was unable to make his own judgments.
Maybe. I don't know. I mean,
maybe means not guilty.
No, I mean, well, look, no, I mean, it has to do with if the guy has the mental capacity to follow the processes, okay, then he can choose which process he wants to follow. And he went off down this murderous rampage process. He could have turned around and said, the way I want to channel this is to look at what the law says and do that.
He could have, yeah. And I think, though, I think the doctor made a compelling point. Now, whether or not that point means that this guy gets a not guilty verdict is a different story. But I think either way, it's a compelling point that this guy was obsessed with Star Wars. He was obsessed with video games. He was somebody that lived in a world where the idea of being a hero was an important thing. And Star Wars in particular, if that is his frame of reference, where you have a situation where it's a corrupt government and where the hero is the person who is acting, against the law in some ways, it may well be a world where he really honestly, maybe unreasonably, but honestly believed that his conduct was doing what was morally right. And if the jury believes that that's where he felt in this.
But the jury instruction doesn't say what's morally right. It means what's legally right.
Well, actually, it doesn't say only legally right, because it says, doesn't it say criminally wrong? But the wording is such that there is certainly an argument that if this guy thought that he was acting morally right, even if it conflicted with the law, that he might well get off. That's my reading of the statute. And there's been lots of case law about these kinds of not guilty
Look, it has
statutes.
to do whether he appreciates the criminality or is unable to conform to the requirements of the law. It's not a question about what he thought was morally right. But morally right does not appear in this.
No, I get that, right? So it's not a strict statutory, like the law says that if he thinks he was morally right, then that's enough. But the idea that he could think that what he was doing was morally right and therefore did it because he can only do what's morally right fits into the inability to conform his actions. Now, I'm not saying every case is going to have those facts, but that analysis could work to make not guilty the correct outcome.
Well, what's
here.
the old saying, being caught by the long arm of the law, don't take the law into your own hands.
That's true,
I can think, look, I mean, you've probably been in situations like this as a lawyer. I can remember digging into them when I was an investigative journalist. The best stories I found were the stories that said the law requires this, but that's causing more harm than good. Mm-hmm. Okay? I'm remembering a story I did about a gasoline refinery or some installation that blew up when lightning hit it. And it turns out because the lightning safety devices that the law requires are so pathetic that there's better ones out there, but nobody uses the better ones because the law requires the lousy ones.
Right.
And so it's one of those things that it's like, okay.
And you don't know what to do. And I think,
if his argument is that he was taking the moral high road by violating the law, my read of these jury instructions has to do with criminality and the requirements of the law. The jury instructions require that the defendant be able to identify and then conform with the law. And if he chose not to do that, but he had the capacity to do it, if he had the capacity to do it, but he chose not to do it, that's on him.
Sure.
Then that means he's guilty.
Well, I'll tell you what, I think it's interesting. We're both lawyers. We're sitting here. We're having this debate about it. The jury is presumably filled with, it's not filled with lawyers. Maybe there's one or two on the jury, but they're certainly not all lawyers. So I wonder what they'll do, because will they really look at this? Will they go word for word? Will they go clause for clause and really understand what those words mean? Or will they say, we know this guy has something wrong with him, and we think that the reason why he committed this crime is because something was wrong with him, and leave it at that, which is a much more simplistic, not exactly correct analysis of that statute.
Okay,
but
so
is that
what you're doing is what I articulate frequently here, and that is that the prosecutor has got to walk them through this in extremely minute detail.
But not so much detail that they get sick of it and they don't do it at all. That's the balance.
I think
that
is
the walk.
Well, you got to look at who's on your jury. Mm-hmm. But most juries, I think, in sitting here around this table, has reaffirmed my faith in the jury system, because we've had cases where I've sat here and said, I don't think the prosecution has met its burden, and they turned into acquittals.
Yeah.
You know, and there are other cases where I think prosecutors were trying to oversell cases, which they shouldn't have done, that resulted in hung juries. And I think it was because the jury was hung saying, you know, I think the defendant did something wrong, but I don't know if he's as bad as the prosecutor made him out to be. So there's a danger in order, you know, I think juries try to do the right thing. And if the judge tells the jury this is what the law is, and the prosecutor says, under the laws of Massachusetts, every one of us can't just go out there and dispense justice as if we live in a Clint Eastwood movie or a video game or whatever your generation considers its, you know, Rambo-esque fashion for dispensing justice. The law says you can't do it that way. The bottom line is he was functioning well enough to have the choice, and he chose the wrong path.
I think
That's what the prosecution needs to get up there and say. And, you know, right now my fear is the prosecution going to be able to make that kind of argument? Are they laying enough evidentiary foundation to make the argument? But that's the argument.
So, and I think that basically here's what we can agree on. What this jury does is going to depend more than anything else on the jury's willingness to follow the statute, their ability to follow the statute, the arguments that are made, and probably what witnesses come after Dr. Kelly. Because if the prosecution brings on another witness who is an even more dazzling witness, and that person says, Dr. Kelly's a quack, don't believe anything he says, here's something else to consider, that might hold a lot of weight. It really depends on who comes next.
I'm afraid that the way this is going to go is that the jury's going to look and say, wait a minute, the state called one guy who said he couldn't tell right from wrong, basically. And then the state called another guy that said he could. The state can't even agree. And then the judge told us that if there's reasonable doubt in there, we have to acquit.
So the state obviously isn't sure. So if they're not sure, why should we be sure and let that's called not guilty by reason of insanity?
So I think that the way that they deal with this is going to be ridiculously critical.
I think that it's going to be almost impossible for the jury to ignore the fact that Dr. Kelly is a prosecution witness. I think that that is such a difficult thing to get around, that the prosecution itself called this doctor and this doctor, everything he has to say hurts the prosecution and helps the defense.
That this is the weakest point in this prosecution's case.
And it's the weakest point in the case, and it's the most critical part from a legal standpoint, because all that other stuff,
because it's all about
important,
the defendant's mental state here.
So I
or
think
not
that
mental state, it's all about whether there's a lack of criminal responsibility.
Right, and I just think that it's very difficult to get around such a damaging prosecution witness, even if they do bring a second witness in that says, forget what Kelly says, I have something else to say. At maximum, the jury is going to walk away and say, well, the prosecution had two witnesses and they disagree. I mean, I think it's going to be very difficult for the prosecution to bring anybody on where the jury wholly discounts Dr. Kelly's conclusions and just goes with whatever the second person says. But, I mean, we'll have to see.
Well, I think the key to this is going to be in kind of going down the path that I just went and said, okay, well, you know, the first doctor said the defendant was just playing out his own version of justice. If they characterize it that way, then they can override what this doctor said. Because it's not about what the defendant thought was right or wrong. It's about whether he could conform
whether or not
right or wrong. And so, okay, great. We just listened to this whole diagnosis, this whole testimony, and we can summarize it as saying that this defendant, due to his diagnosis, was just sort of playing out his version of justice. Well, again, you can't go out, the law says you can't go out and just on your own determine right from wrong. It's about following processes.
So here's my question. Do you think that in this case, if Adrian Loya were your client, would you have him testify to have him discuss what his mental state was, what he was thinking, how his brain works? We already have a case where we know that he did it, right? It's not like he's going to say, like, well, I didn't do it. So isn't the best evidence of what was going on in his brain him and his own testimony? Wouldn't he be the most
I don't
credible
think,
person?
I don't think that I would, because where's that going to go? He's
Well, if
going to
he
try to
gets-
sit and say, I didn't know how to follow the law. Well, then he's recognizing that there is a law that he at least knew about and in theory could have followed. And if the prosecutor is any good at the cross-examination, say, hey, you took all this time laying out these plans. Did at any point you pull open a statute book?
But if he gets
And
on the
follow
stand,
that process.
if Loya got on the stand and was a disaster on the stand in whatever way, that in terms of answering questions, his affect, his general kind of mental process, if he comes off as somebody who is not right and has some screws loose, won't that only help him no matter what he says?
Because the law isn't about whether he has, in your words, a couple of screws loose. It's
No,
not
but
about
the law
his
may not be, but the
diagnosis.
jury system may well be.
Well,
I mean,
then-
this is a
then-
trial.
Okay, so then the prosecutor would have to be really, really strong in closing arguments to draw the distinction between, look, even considering the diagnosis, the question isn't whether he struggles with things, whether he has a diagnosis. That's not the issue. The issue is whether he could have conformed his behavior to what the law requires.
Let me say this, though. And you are the best person in the world to be talking with this about, right?
Well,
Why
because
does
I've
the
been
world-
dealing with it for the last couple of
Why
days
does
here.
the world know that Brendan Dassey's conviction was wrong? Because of what he said? Not really.
Well, let
Because
me
of how
back
he
up. Let me
seemed.
back up. Let me back up. I'm going to be
Yeah.
careful about the way I characterize the Brendan Dassey case and the Making a Murderer
Yeah.
film, because here's the thing. You can listen to what he said and you can view it one of two different ways. You can believe that he was trying to lie his way out of something that he knew, okay?
Mm-hmm.
And that he slipped truth in there as part of it. Or you can believe that he was fed everything, which is what the
Right.
initial 3-judge panel in the Seventh Circuit found. So here's the thing. The people who were in the courtroom when the jury watched the interrogation recording the jury, by their body language, made it very clear that they were falling in the first camp. That they believed that he was a shifty kid who had been coached to lie about things, but that after some wearing down by prosecutors that he needed to tell the truth, that he finally did tell the truth.
Okay.
The jury was very clear in its body language that that's what the jury believed. Okay, now whether the jury was misled or mistaken, I don't know. But see, here's the thing. I'm not the one that's litigating that case. I respect the attorneys who have litigated it, most of them at least. And, you know, at the end of the day, that's what the jury found.
But what I'm saying is this, though. If you look at the massive public reaction, I'm not really talking about the jury in that case as much as I
The
am.
public wasn't sitting in the jury
you're
box.
right,
though,
you're right,
And
but
this
what
is
I'm-
why I say all the
Yeah.
time, if you read one or two things about it or even watch a 9-hour film, you still didn't live through weeks of testimony.
But
The
what I'm saying
jury
is that look
did.
at the intense reaction so many people have had from watching the portion of that tape that was played in the film. That is an intense reaction. Whether or not it was fair or it captured everything that happened in the courtroom is kind of a separate issue. But what I'm saying is that
Well,
many
that
people,
is the issue, though.
But what I'm saying is that many people looked at that and said, "This is not fair. This kid should not be convicted." There is at least a possibility that whatever may happen on the stand, if Loya were to testify in his own defense, that the jury would watch it and come to the same conclusion: it's not fair for this guy to pay the price. However that may happen, there
Look,
is a
if
reaction
If he
there.
testified, okay, boy, I don't know what to even predict. I was going to try to predict something, and I don't think that
So
I
you wouldn't
could.
put him on the stand. If you were the defense lawyer, you would not put him on.
It's almost too unpredictable, but I guess at this point, does he really have much to lose based on... It's good. Look, it's going to be interesting to see what's the prosecution's case in chief. It's
I think
almost the
it
kind of
depends.
decision.
I mean, if I were the defense lawyer, that decision would rest entirely on what he's like in real life, which is something I don't know right now.
Yeah, we don't know that.
I mean, if he's somebody who comes off with a very flat affect and very detached and someone who seems odd, crazy, unpredictable, that might work well for him. If he is someone who comes off as perfectly normal, then obviously that's not going to be a good call for them. So I think, I doubt he will testify. Defendants almost never testify on their own behalf. This case is already strong for the defense even without that, so it is exceptionally risky to put him on the stand. I just think it's an interesting exercise to play.
Well, and, look, since you want to argue about the Brendan Dassey case, here's another thing that I'll bring up with that. The big issue is, I said there's two different ways to view it. Well, if the jury is split 50-50, then the state hasn't proven its burden beyond a reasonable doubt.
That's right.
So if I were on the jury and I really thought, well, it could be one or the other, then the choice should have been to acquit. Okay, that's one thing. And then the second thing is, well, what's the standard for a confession? The standard is you have to completely give yourself up. Okay, it's really a defendant sitting in an interrogation chair, unburdening himself, becoming his own accuser, is the language that the Supreme Court keeps using. It is not a standard for having information pried out of you.
Well, let's see. We can talk about this for hours. We're gonna go back to the courtroom. We're gonna look a little bit more at Dr. Martin Kelly's testimony. Their lunch break.